University of Dundee's Freedom of Speech Society event. Whether you're here with us via Zoom, live stream, or listening to this later on our podcast or through our YouTube, it's with great pleasure that we welcome you to tonight's event regarding the passing of Scotland's new hate crime bill. Firstly, I'd like to welcome and thank Jade Kouletakis for speaking with us tonight. I do believe this will be a very interesting event indeed. Okay, so I'd just like to start by giving a brief introduction. So Jade has been a lecturer in law at the University of Aberdeen since 2017, where she's also the founder and academic president of the Law Moot Club, a member of the university's Research Ethics Committee and Equality and Diversity Committee. Prior to joining Aberdeen University, Jade had acquired over 4 years experience in teaching law at universities across South Africa, most notably the University of Western Cape and the University of Cape Town. Jade's focus is on public law, intellectual property law, and public policy. She holds a Bachelor of Arts in Law, Media and Writing, a Bachelor of Laws with Honours, and a Masters of Law in Intellectual Property Law. Externally, Jade is a steering committee member of Scotland, which stands for the Scottish Law and Innovation Network. She's also worked with the Global Expert Network on Copyright User Rights and South Africa's Freedom of Expression Institute in the formulation of South Africa's controversial Copyright Amendment Bill. So just as a side note, I'll quickly explain the format of this event. The event will start with Jade giving us a talk, followed by a Q&A session. If you do have a question, please make sure to pop it in the Q&A function that you should see on the bottom of your Zoom tab. And yeah, so without further ado, again, Jade, thank you for speaking with us. And if you're happy to make a start, then yeah.
Great. Well, thank you very much to the Free Speech Society for inviting me to give this talk. I think it's important, before we start really critically analysing the bill, before I start telling you what I think is wrong with it, we have some common context, firstly on where the bill comes from, what the purpose of it was, and secondly, what the bill actually says. So in terms of historical context, we go back to 2017, where someone named Lord Brackadale was appointed to undertake an independent review of hate crime laws in Scotland. So he was appointed to look at the law in Scotland as it pertains to hate crimes and to publish what he thought about it, what he thought was good about it, what he thought was bad about it, to make recommendations about how he thought it could be made better. And he did this in 2018. He gave his report, his final report, to the Scottish Parliament. The overarching theme and recommendation in his report was that the laws relating to hate crimes were very difficult to actually locate. It was difficult for lawyers, let alone lay people, ordinary people, to find them. And this is because before the bill, there was no one hate crime legislation. If you wanted to find out about hate crimes in Scotland, you had to go to this piece of law, that piece of law, this court of session case. It was all very convoluted and very complicated. This is not a good thing, because we want the public to have access to the law. If the public don't have access to the law, if it's not easy for them to find out what the law requires of them, then we can't reasonably expect them to act in accordance with the law. You only know what you know. And this is particularly important when it comes to vulnerable groups, to minority groups of people for whom one would reasonably argue, and I think everyone could agree, access to the law is all the more important. So his main suggestion, namely that there be an act, a piece of legislation, like the hate crime bill, that collates or brings together all of these different bits and bobs of law relating to hate crimes into one place so it can be more easily accessible by the public, is something that the bill does do. So in principle, the bill is a good thing. And I'm not here to attack the bill in principle, right? I think increasing accessibility to an understanding of law is always a positive thing. As I've said, particularly when we're talking about the potential victims of hate crime, the most vulnerable members of society, for whom access is perhaps more important, or all the more important. The primary concern I have with the bill pertains to law. So it's not something that Lord Brackadale recommended to Parliament. It's something Parliament decided on their own. They wanted to do a change. They wanted to bring in themselves. And in fact, Lord Brackadale has expressly said that he disagrees with this change we're going to talk about today. So he would hopefully support and find persuasive the arguments I'm going to be putting before you today, to try and illustrate why that is, what makes this extension of the law so problematic. But before we do this, we need to have a common understanding of what the bill actually says. We know it's about hate crimes, right? The media tells us that. But what is a hate crime? So the first thing we need to know is who can be the victim of a hate crime. In other words, who does the law protect against hate crimes? Now, the bill recognizes people who either hold or are believed to hold a closed list of so-called protected characteristics as being the people protected within the bill. That's why they're called protected characteristics. If you have that characteristic, you belong to a class of person who the law will protect against hate crimes. This closed list includes age, disability, sexual orientation, transgenderism, religion, nationality, and intersexuality, right? And I did learn that, right? I learned that off by heart just for this. Now, moving on to how we define hate crime, we now know who the victims of a hate crime can be, who the law recognizes as needing protection. We now need to ask ourselves, what is a hate crime? What actions constitute a hate crime? Now, for the purposes of this discussion, I want to focus on the crime of stirring up hatred, which can be found in section 3, subsection 1 of the bill. If you are found guilty of stirring up hatred against one of these protected characteristic groups, you face a prison sentence of up to 7 years. So it's quite a serious crime. The offense of stirring up hatred pertains to someone who acts in a way or shares materials that a reasonable person would consider to be one of 3 things: either threatening or abusive, or, and this is the extension we're talking about that I think is problematic, insulting. Now, acting in a way that's abusive or threatening, or sharing materials that's abusive or threatening, is just never okay, right? It wasn't okay to abuse or threaten people yesterday. It's not okay to abuse or threaten them today. The bill hasn't changed that. The bill has crystallized the law on that, but it hasn't changed it. In fact, I would say in most right-thinking countries, it's not okay to go around abusing or threatening people, right? The problem, as I've said, is in Parliament deciding that they would like to extend the scope of this crime to cover mere insults. So the criminalization of insulting behavior or communications, this is something new. This was not the case before the bill. So the bill is seeking to change hate crime law in Scotland insofar as it criminalizes insults. And as I've said, this is something Lord Brackadale has expressly said he takes issue with. He does not condone this. He thinks it's wrong. It's also something that the Faculty of Advocates have said they take issue with. And it's something that the Law Society of Scotland have also said they take issue with. Obviously, this is argument by authority. There's no reason why you can't disagree with Lord Brackadale, the Faculty of Advocates, and the Law Society of Scotland, right? We're all independent thinkers. And if you disagree with them, that's fine. But what I'm wanting to do today is put to you substantive arguments for why I agree with these bodies, why I think that extending hate crimes to insults is, from a legal point of view, deeply problematic. So the first reason I think it's problematic from a legal point of view is because I think it arguably violates international human rights law, which the United Kingdom, including Scotland, must abide by. The 2 examples I'm going to focus on are freedom of expression and freedom of religion. Now, there's a lot of international case law that explains to us what countries must protect under the right to freedom of expression. In other words, the sorts of expressions that countries cannot criminalize. The definitive test comes from as far back as 1976 in the case of Handyside. And in this case, the International Court said that countries must protect not only information or ideas or expressions that are favorably received or inoffensive, they must also protect that which, and I'm quoting, offends, shocks, or disturbs. So this notion of expressions that are offensive, shocking, disturbing, yet which the international community still requires countries to protect under freedom of expression is a very broad one. The international courts take a very liberal approach to this phraseology. And I think the best way to sort of illustrate how that is, to illustrate how broad and how liberal an approach they take, is by looking at some case examples. So everything I'm going to say to you as an example comes from an actual international case. They include, for example, a public denial of genocide, saying that people who disagree with you, your rivals, are lovers of the infidel who have waged a war against God. Taking the photographs of people who you presumably don't like very much and setting them alight in public. Referring to a group of people, a whole class of people, as being pigs and the dumbest, uneducated animals in the world, and saying that a particular religion is immoral and its prophet a frightful creature. So as I said, all of these examples come from actual international case law. So I am quoting when I say that, so don't come for me, right? So when we say that the international court says we need to protect expressions that offend, shock, and disturb, I think these illustrative examples really crystallize for us that they mean it, right? They really mean it. When they say expressions that are offensive, shocking, or disturbing need to be protected, just because society doesn't like them isn't enough to criminalize them. They paint that with a broad brush. The International Court has also said that just because individuals with protected characteristics, or just because society as a whole considers something you've said or something you've done to be offensive or insulting, is not in itself enough to justify making it a criminal offense. In fact, there's a quote from the case of Vajne versus Hungary from 2008 that I really like. Some background into the case, it's where you had a left-wing politician in Hungary who went to a public event, I think it was a demonstration, and he was wearing a red star, a red five-pointed star, which, if you are in Hungary, you would know is a well-known symbol of the communist totalitarian rule that was experienced within living memory of many a traumatized Hungarian. And in this case, the court said in paragraph 57 that a country or a legal system that restricts human rights, in this case, freedom of expression, in order to satisfy the dictates of public feeling, cannot be regarded as a democracy. To hold otherwise, the court said, would mean that freedom of expression is subjected to the heckler's veto. So in other words, what the court is telling us there is that just because you've said or you've done something that has offended a lot of people, or may even have offended society as a whole, doesn't necessarily mean that your government is allowed to stop you from saying it or put you in prison for 7 years because you said it. There is a difference between the morality of what you say and the legality of what you say. Those are two separate things. Now, you may disagree with this position, right? You may look at international human rights law as I've described it, and you may say, this is abhorrent, this is terrible, right? This can't be right. We need to fix this. We need to change this. And that's perfectly fine, right? Laws change all the time. Laws are constantly changing, for better or worse. The laws of 50 years ago are not the laws of today. So if you think it should be changed, fair enough, go about changing it. But that doesn't alter the fact that this is the position in international human rights law today, and that the UK, including Scotland, is under a legal obligation to abide by this international human rights law as it stands today. In criminalizing mere insults, Scotland is, as I hope I've persuaded you, as I hope I've illustrated, arguably not abiding by these international human rights standards. In addition to freedom of expression, which I think is the most obvious issue regarding the bill could also potentially violate other international human rights, for example, freedom of religion. This could be the case where, for example, you air an opinion that may be considered insulting, but at the same time, it's also found in a genuinely held religious belief. For example, you may post quotes from the Bible on social media, right, saying that marriage is between one man and one woman. Now, this could be considered insulting to homosexual people, transsexual people. It may even be considered insulting to the overwhelming majority of society, right? But that is still based on a genuine religious belief. Now, the way that the law has tried to balance, on the one hand, protecting freedom of religion, and on the other hand, the interests, right, the justifiable, the necessary interests of others, particularly members of vulnerable groups, right, particularly members who have protected characteristics which are spoken about, people who are homosexual, people who are of a different race, right, on the other hand, is by saying that there's a difference between treating someone badly because of who they are and expressing a sincerely held belief. Now, just full disclosure, I am giving an exceptionally superficial approach to how the law balances freedom of religion and competing interests for the purpose of this discussion. Ordinarily, this is something I would dedicate a whole 2-hour lecture to, and it's something that I actually have final year students writing a whole 10,000 word dissertations about. So this is an extremely superficial look at the balancing act the courts take. This is not in any way, shape, or form sort of a definitive thing. Now, in the first instance, you would be breaking the law, right? In an instance where you're treating someone unfavorably or less favorably due to who they are, due to a characteristic they hold. A good way to illustrate this, I think, is by way of an example. So let's imagine that you are gay, or if you are gay, just imagine you are you, and place yourself in 2 different scenarios. Now, both of these scenarios come from cases. So they are real life scenarios that have happened, and we have cases that exist to tell us what the outcome is. Now, in scenario 1, which is based on the case of Lee versus Ashes, imagine you went into a bakery to buy a wedding cake because you're getting married. Happy days. I have absolutely no idea how you managed to find someone to marry during lockdown, but I suppose love will find a way, right? And you go into this bakery and you order the wedding cake, but the owner of the bakery is a staunch Christian. And the owner says that they are not going to provide you with a wedding cake because they do not support gay marriage. They think gay marriage is wrong. They therefore refuse to give you a wedding cake. In this case, that would be unlawful because you would be treated less favorably due to being a homosexual than somebody who is not a homosexual. So if I had gone into the bakery, I am a heterosexual. If I were to go into the bakery and ask for a wedding cake, I would be provided with one. You are not provided with one because you hold a protected characteristic. And in that case, the court is clear that that is unlawful. It doesn't matter that you are expressing a genuinely held religious belief. You can't discriminate against somebody else. Now, in scenario 2, imagine you're scrolling through your Twitter feed, right? This is based on the case of Ngoli versus University of Sheffield. and you see a tweet where someone is quoting from the Bible and they're saying that homosexuality is a sin. Now, in this scenario, you may look at that tweet and you may well feel insulted or offended or shocked or disturbed. You probably would feel all for, right? And even if you were not homosexual, right, I would think that the majority of people would look at that tweet and feel offended by it. The majority of people would not like that tweet. But that does not make it unlawful, right? There is a difference between being offended, shocked, disturbed by that tweet and the tweet being unlawful. The person who made this tweet hasn't directed it to you. They haven't threatened you or abused you. They haven't interfered with you in any way. You may think that they're a bad person. You may think that they're an immoral person. You may think they're an abomination to the human race, right? And most people may support that, right? But that doesn't make them a criminal. Now, the bill could change this because airing opinions that are founded in genuinely held religious beliefs could be considered insulting. And this is arguably a violation of freedom of religion under international human rights law. Again, you may not like that. You may want to change that. That's fine. But that doesn't alter the position right now. Now, moving on from international human rights laws and my concerns about those, I also have a potential concern with criminalizing insults in relation to it potentially undermining the democratic process in how the Scottish Parliament goes about making laws. So it's an established feature in all democracies that when a parliament is considering a policy change or making a new law or changing a law, they will ask the public to share their views on these proposed policy changes. This is the case in Scotland. Before the Scottish Parliament makes a new law or changes an old one, they ask the public to comment on it, and they then consider this public feedback going forward. Now, public participation in the way that Parliament creates policy is extremely important in a democratic society. It's important for a host of reasons. The first one is that it just, on the face of it, right, even if you're not a lawyer, even if you're not a legal expert, it just seems right and just that if we're all expected to abide by laws, which we are, then we ought to have some say in what those laws will be. We ought to have some say abide by the law, regardless of whether it directly applies to us or not. So I may not own a car, but that doesn't mean road safety legislation doesn't apply to me, right? So just from a basic humanistic point of view, from a justice point of view, it seems right and just that we should have a say in the laws we are governed over. The second, which is a bit more public law, more legal, is that it facilitates something called open governance. Now, what do we mean by open governance? When we have elections, right, we go to the polls and we vote for politicians who we expect to act in our best interests. So we give them a public mandate. We tell them, you can have this power to be in Parliament, to make laws, but we want you to do it not in your own best interest, to us. So if a politician is voted into power and they spend their entire duration in Parliament doing stuff we don't like, then when the next election comes around, right, we vote for someone else. So that politician loses their job. We pick another guy, another person. Politicians, therefore, do very well to make sure that when they are changing policy, they sort of check in with the public, right? They do well to consider the public's opinions, the public's views on matters of policy change so that they can make sure they're doing stuff that we like, things that are in our best interest, so that when the next election comes around, we'll hopefully vote for them again and keep them in power. The third is that people in general will be more likely to respect and abide by the law if they feel like they've participated in its creation. So this is sort of like the idea where childcare experts, I don't know, Dr. Phil or two, is get them to help you make it, right? Get them to help you prepare supper. And that way, they're more likely to eat it because they've helped you make it. So it becomes their, but it's something that they made. So they're more likely to accept it. The same principle applies to the public and the law. People are more likely to follow a law, to abide by a law, if they feel like they've helped to shape it, helped to create it, even if the law ultimately doesn't reflect the content they would have preferred. Now, when we say we need to protect the public's ability to comment on policy matters, we mean that we need to do so no matter how crude or offensive that commentary may be. As we discussed when we spoke about freedom of expression, right? Freedom of expression covers content that offends, shocks, and disturbs. It's the same thing when we're talking about political commentary. Political commentary that's crude, offensive, disturbing, shocking is still worthy of protection. We also need to protect the public's ability to express themselves, to express their thoughts on policy change. You may want to air your thoughts on policy matters by writing to your local MP. Someone else may choose to make a post on social media. Someone else still may choose to host a protest in the public square. All of those are valid, lawful, protected. The importance of protecting political commentary is very well established. In the Kingdom specifically, I think a good example of this is, I can't remember, I think it was two of an abortion taking place. And the BBC refused to air it. They said, this is going to be offensive. We don't want to put it on TV. But the highest court in the UK at the time, the House of Lords, said that the BBC must be encouraging members of the public to violate the bill. Right, which I think is rather ironic. So, for example, which would make it easier for someone to legally change their gender, the government might be stirring people up to air opinions that could be considered insulting under the bill. A good example of this comes from England, and it's the case of Harry Miller versus Police Constable Humberside. I think it was from 2020, so a very recent case. At this time, the English government were asking for the public's views on amendments to their Gender Recognition Act. So basically asking for commentary on changes that would make it easier for someone to be legally recognized as belonging to the opposite gender. And Harry Miller went on to, I believe it was his Twitter account, to share his views on these proposed policy changes. And his views were essentially that he did not agree with them because he thought that they were biologically unsound. And this resulted in him being taken to court for hate speech against the transgender community. Now, while he would not be the case if those facts were transported into Scotland once the bill has come into force. In fact, I find it very difficult to imagine a scenario or a way in which an ordinary member of the public could disagree with such amendments while not being guilty of hate speech under the bill. And that is very worrying because that essentially means you can't disagree with it of having a democratic process. So as I've said before, public participation in the way the country makes laws and policy changes is a central feature for any democracy. If you're stifling this in any way, that is arguably not a democratic thing to do. So, that is not an insignificant problem for everybody, right? Because to discuss before finishing off is I want to discuss concerns. Issues around academic freedom in UK universities is not something that we can blame the bill on, right? Issues about academic freedom predate the bill by years. So issues around academic freedom in UK universities have, according to official documents, existed before the bill, independent of the bill. If we go back to 2018, we can see that there was a joint committee on human rights that held an inquiry into the state of free speech at universities across the whole UK, including Scotland. And the committee found that there were concerns about high levels of bureaucracy and also about self-censorship among academics and students on university campuses. This was also endorsed, right? It was followed on and endorsed by the Equalities and Human Rights Commission. So you have two separate bodies endorsing these findings. And more recently, I think it was in January, February of this year, the Department of Education released a report that said essentially that there was a growing body of evidence that people on campus at universities may feel unable to express their cultural, religious, or political views because they're fearful of repercussions. So issues with academic freedom and universities in the UK is nothing new, like I've said. But I do think that it's easy to foresee situations where the bill could make what, according to official reports we've just discussed, is perhaps a bad situation even worse. I think most interestingly are scenarios where you've got subjects that pertain to historically marginalized communities or communities with the very protected characteristics the bill supposedly wants to protect. So I'm thinking of, like, for example, very important from an academic and social point of view, areas of scholarship like queer theory, gay and lesbian studies, race studies, gender studies, religious studies. I've run out of stuff to say, so you get the idea, right? Those sorts of things. So in my opinion, the bill could potentially have a damning effect on these very important, these culturally, socially, academically important areas of academic endeavor. So for example, say we were teaching a class on queer theory or gay and lesbian studies, and I wanted to discuss with you the historical criminalization of homosexuality, because I wanted to discuss how there's overlap between media perceptions of marginalized society and societal perceptions. Now, in this case, if I were to show you, say, a public service announcement from the 40s or 50s that warns the public about the homosexuals among us, and this really is a thing. You can find it on YouTube. It really was a thing back in those days. If I showed that to you, this could potentially violate the bill because it's insulting. Now, obviously, the reason why I'm showing it to you is because it's insulting. That's the point. The whole point is that this is an insulting thing. And I'm wanting to illustrate to you how this was just acceptable back in the day, whereas it's not acceptable today. So ironically, the bill could detract from the sorts of subjects that one would assume it would like to protect. And additionally, even if you've got subjects that on the face of it have nothing to do with marginalized communities or protected characteristics, you can still fall foul of the bill. So for example, say you're a film or a media lecturer and you want to discuss representations of race in film, right, and how it reflects changing societal values. You can violate the bill by showing racially insensitive material. If you're a Roman law lecturer, right, and maybe you refer your class to the writings of Grotius or some key institutional Roman writer, that may be found to be insulting because almost all of them use illustrative examples of slaves as property. So we can see that there are many ways in which the bill might make a bad situation worse in terms of stifling academic freedom across a host of subjects, including the important subjects pertaining to protected characteristics that it should try to protect. So just to conclude, the criminalization of insults in the bill, I think, is deeply worrying because it potentially violates international human rights law. It potentially diminishes the democratic process by which policy is made in Scotland, and it potentially limits academic freedom, including for subjects that highlight the shared history of marginalized communities. And for all of those reasons, I think that the bill is seriously flawed insofar as it criminalizes insults. And my recommendation would obviously be that Parliament amends it and takes out the bit about insults, because I think that would fix a lot of the problems. Thank you.
Thank you very much for giving that talk. That was very, very enlightening for anybody listening, and I think that you you really gave us a very comprehensive understanding of the perspective on this bill, especially from a law perspective and not just from a social perspective. So I suppose on that note, you've answered a few of our questions already in your opening talk, which is very, very good. But I think the first question then would be, would you say that the main problem is that the bill scope is too wide as opposed to the bill itself actually being fundamentally flawed? Like, as you said, if those parts about insults were removed from the bill, do you think that it could be viable?
So my position is not that the bill as a whole is like the sport of Satan and we need to exercise it, right? So my position is that there are good things in the bill. The bill serves a very important function and the bill does a lot of good. The key example is that it does follow through with the main recommendation of Lord Brackendale. It does crystallize this area of law, make it more accessible to minority groups. And that's an exceptionally important thing, right? That's extremely important. My issue is to do with the particularities of the bill, namely the extension to insults. So in my opinion, if you were to take out reference to insults, if you were to say hate crimes constitute instances where you behave in a way or you share materials that are abusive or threatening, and you end it there, you don't include insults, to my mind, that would go a very long way to saving the bill, to making sure that we don't just throw the baby out with the bathwater, to use a phrase I absolutely hate. I just can't think of anything else. There are other debates happening around the bill, which are more political. So, for example, when I listed the list of protected characteristics, there are political debates about whether some characteristics should be in there or whether other ones should be added. So there's a whole big thing about whether sex should be listed as a characteristic, which it's currently not. That is not something that I would comment on because to my mind, I would see that more as being politics than being law. So that's not something that I would necessarily feel comfortable commenting on in my position as a legal expert. So it would be my job to discuss with you the bill in its current form and why I think it's problematic.
Yep, that's very interesting. Kind of in relation to that, do you think that the bill would be acceptable if it excluded topics that aren't yet widely accepted in our society? For example, transgender rights.
Could you rephrase that?
So do you think that in terms of the bill being viable, it excluded topics that are quite sensitive in terms of general acceptance of our society, so transgender rights?
Okay, so it would be my position that transgenderism should be included as a protected characteristic. So my position is that it's not really debatable, right? So we have I can't refer to it right now, but there is a government report that's very recent. I think it's from like 2019 or 2020 about the experiences of LGBT members of society. And I mean, if you read that report, it's shocking, right? It's really depressing how marginalized they can be in society, and that's not acceptable. So I think you clearly need to protect the vulnerable in society. So protecting transgender people, intersex people, race, religion, I don't have a problem with any of the protected characteristics in the bill. I think that we should have hate crime legislation protecting them. To my mind, right, I think what you're asking about is insofar as the bill stifles important democratic debates relating to topics pertaining to people who are holding protected characteristics. How can we go about fixing that? And I think that if we were to eliminate the criminalization of insults, I think that would be the correct thing to do, because if you're getting rid of insults, then it's only if you're abusing or threatening somebody who has a protected characteristic that you would be guilty of a hate crime. So if you were just criticizing that class of people, or if you were discussing laws around that class of people, that would not be a crime if we took out insults, because insults is there. Just discussing it, right? Just discussing, for example, the Gender Recognition Act, and not having a positive answer would be an insult, and that could be criminal. So I think that the ends that you're wanting to achieve can be met by taking out insult. I never think it's a good idea to minimize legal protection for vulnerable members of society.
I think that was a very good explanation of your stance on it, and I think we'll take a question from the chat now. We have a question from Richard here that says, is it not condescending in some sense to assume that people in these protected categories need/want protection from the government other than protection from violent attack or incitement to violence? I personally find the first two terms of the bill vague enough to unduly inhibit the freedom of speech/religious practice of individuals in many cases. I say this as a member of one of these protected categories that wouldn't like to be protected in some abstract sense by the government. Do these terms then need to be more clearly defined, in your opinion?
Okay, so that's an interesting question. I'm also somebody who falls within a protected characteristic because, in case you're like hard of hearing, I'm not Scottish, right? I come from South Africa, so I'm foreign, and being of foreign nationality is a protected characteristic in the bill. So I think that if you don't want that protection, you are free not to use it, right? It's not making you have to sue people. The bill doesn't say that if you see something that is abusive or threatening, you must instigate legal action against them. You don't have to do it, right? If you don't want to, don't do it. What it's doing is it's giving that option to other people who would like to do that, who would like to protect themselves. And incidentally, the standard of criminalizing abusive or threatening behavior, right? You may want to change that standard. You may say, I don't want to criminalize abuse or threats, which again is fine. It's not my place to tell people what their positions ought to be. But what I can say is it's pretty much accepted across countries. Even outside of Europe, it's pretty much accepted everywhere. Even in the United States, by the way, you can't abuse people, you can't threaten them. That's a legal standard that is pretty well accepted in the international community. So, I think that there's a lot of support for that. You may not want to use it, but just because you don't want to use it doesn't mean other people don't. So, I've never experienced certain crimes. That doesn't mean that I think they shouldn't be crimes.
Absolutely. I have another interesting question from Matthew in the audience. He says, as the Scottish Parliament must pass legislation that complies with the Human Rights Act, do you foresee that the insult part of the bill possibly breaching this by infringing freedom of expression and becoming void ab initio? Or at the very least, is the Scottish Parliament pushing the limits of its competency?
Hello, Matthew. Matthew is one of my students. Nice to see you. So in my opinion, I would say that it could be rendered void ab initio. So what void ab initio means is that it is sort of aborted. So it never becomes law because it violates some other fundamental law. In this case, the Human Rights Act. But this is a whole legal thing I'm not going to get into. But the issue with that is it would require somebody to sue. So it would require somebody, presumably someone who is being charged with committing an offense under the bill, to go to court and argue that the bill is a violation of freedom of expression and therefore should be expunged, should be tossed out. Now, this sounds fab, right? This sounds nice and well, but in reality, it would take a certain type of person to do that, right? It's really difficult to dedicate 2-3 years of your life suing somebody in court, which is generally what we're looking at when we're going to court. And if we add on appeals going all the way up to the Supreme Court, we're looking at years and years. It's also really expensive to do that. And if you lose, you're probably not going to be in a good financial situation. Additionally, it's also, I mean, I've never had this experience, but I would imagine it's very difficult to, get a job when you've got a hate crime allegation sort of floating over your head. I can't imagine many people running to hire you during that time. So even if you were ultimately going to be successful, you would have to dedicate a lot of resources and sort of dedicate a lot of time and make a lot of personal sacrifices in doing that. I would think what could also happen, apart from going a sort of legal route, could be to go a political route, right? So people can exercise their dissatisfaction with their vote in the election. They can exercise their dissatisfaction by writing to their MPs. They can, we have a lot of political, a lot of civic opportunities to bring about change, as I think we've seen. And there's no reason why you can't utilize that for a bill. As I've said, Parliament has to be accountable to the people, and the people are able to hold them to account ultimately, one way or another.
On that note, what would you say would be the best way for the public to express their dissatisfaction for this bill and to actually make a change, outside of like campaigning or marching or anything like that?
So I'm trying not to be involved in politics. So I think that the best way of showing your dissent with the bill, so I am somebody who has written to my member of parliament. I've actually been in the Courier because of a matter I had with the government. So I am by no means sort of shy of contacting my MP and raising concerns with them. And I think you ought not to be either, right? You pay them a very good amount of money with your tax every month. So if you have an issue and you want them to deal with it, you should by all means write them a very polite and respectful little note and tell them that you are unhappy with the bill. You can also, as we've said, through representative democracy, you can exercise your dissatisfaction by the way that you vote the poll. You can also start there's nothing wrong with a campaign. You say it like it's a terrible thing to start a campaign. What? Right? Like we can start a campaign. A campaign can be perfectly civil, it can be perfectly peaceful. You can start a sort of a roster thing that people sign and you present it to Parliament. I think also doing things like this. So one of the reasons why I agreed to come onto this talk, I'm officially on leave right now, but I still wanted to come and give this talk because I think that by sharing information about the bill and why it's so important will help members of the public to realize why they ought to be upset about it, even if it doesn't directly affect them, right? So even if you're not intending to commit hate crimes against anyone, it still affects you because it's a bad law, and bad laws affect everyone. They don't just affect people over whom they're applicable. So I think information is also something that can be very useful.
Absolutely, I agree. From a general perspective, you think that this bill will take us closer to a 1984-like state in which the notion of privacy is just a happy memory?
So I think that the bill is, as I think I've tried to argue, has problems for democracy, right? I think that it can stifle democracy. I think stifling democracy is never a good thing. I think that additionally, there's this idea, which I find very interesting as a legal person. There's this inability for some people to sort of separate out morality on the one hand and legality on the other. So, this conversation we're having, right? It's not about, going around hurting people's feelings, right? Of course, it's not nice to hurt people's feelings. If you go around hurting people's feelings all the time, you're probably a bad person and nobody loves you, right? That's not what this conversation is about. This conversation is about criminalizing hurting people's feelings. So should someone have a criminal record for the rest of their natural born life and spend 7 years in a glum and dreary 5 meter square jail cell because they made you feel bad? And my position, which is, as I said, shared with the international human rights community and every civilized society in existence, is what? Like, absolutely not, right? there are concerns about privacy that you've also raised too. So that would pertain to the dwelling defense. So essentially, you can commit a hate crime even if you're in your own home. So if you are in your own home, and the classic example that I've seen in the media all the time is you're having dinner and your very old racist uncle or homophobic uncle or whatever says something around the dinner table, and then a member of the family calls the police, then he can be taken to prison. So that is, to some people, seen as being an infringement of privacy because it's bringing the law into your home, right? Now, bringing the law into your home is not a new thing. So I can't punch somebody in the face in my lounge, just the same as I can't punch them in the face if I'm at Tesco, right? In that way, the law comes into my home. So coming into your home isn't necessarily a problematic thing. There are justifiable reasons for doing that. I think that the concern here comes from the home being a place where you can have open discussions about things without being filtered, without needing to really check yourself so much, and to be able to have this open dialogue about sticky situations, about difficult situations and difficult topics. Insofar as the law coming into the home pertains in this case, Roddy, I can't remember his surname, but he's the head of the Faculty of Advocates. He said that he found it to be rather draconian, which I think is a very nice way to put it. Do I agree with the law coming into people's homes in this particular instance? I mean, I think, again, if we were to get rid of insults as being criminal, this would go a long way to sorting that out. So there's a difference between, the example that Humza Yusuf likes to make is you can't have a group of Nazis coming into the lounge planning their next attack, right? That's going to be criminal. And that would be criminal, right? That should be criminal. Obviously, that should be criminal. But there's a difference between that and having an insult in your lounge, right? So I think that in terms of criminalizing abusive or threatening behaviors or communications, yes, the law may be justified in coming into your home because abuse isn't okay outside, it's not okay inside. You can't beat your spouse outside and beat them inside with impunity. So in that case, I think it's a stronger argument to make. I think, again, if we take out insults, this wouldn't be such an issue.
Yeah, I would agree very, very much with what you say there, especially in regards to the fact that, like, and there's a very clear difference between an insult and abuse. Like, an insult can be anything from a personal opinion that you hold for religious reasons or something you're saying just to be nasty. But either way, that's not something that should specifically be criminalized.
It's also, abuse and threats are an objective thing, right? Like, you're either being abused or you're not being abused. It's an objective standard. Whereas an insult, I mean, you may find something insulting and Grace may be hunky-dory with it. So that's a far more subjective thing. And when we start getting into subjectivity and the law, that's necessarily going to cause problems because you can't anticipate what in that case will be considered unlawful.
Precisely. We have a message in the chat here as well, another question for you, which is, it doesn't list the name, but it says, as a working professional in the field of law who is against large parts of this bill, what options are there for you and your colleagues to act against this within the legal system in a non-political way?
So firstly, I would say I'm not against large parts of this bill. I'm against a single word, right? There's literally one word in the bill that is my problem. It's a very big word. It has massive implications, which is what I've spent 30 minutes discussing. But it's a very small part of the bill. I mean, the bill is pages long. So my issue is literally with a single word. So the solution is a very simple one, to take out insults. As I've said, the options for people to act against this, if you're a lawyer, if you're a legal expert like I am, so I see the most important thing that I can do is to speak out against the bill, to educate people on what the bill says, why the bill's problematic for everyone, to sort of galvanize change, because it's not going to be the case, I don't think, that lawyers are going to change the law. I think it's people who change the law, society who changes the law. I'm not a special human being because I have law degrees and I teach law, right? I'm just a normal person with a fantastic headscarf. And I think that in galvanizing the general public to be against this bill, that's what makes a difference. Because remember, we pay politicians, right? They don't get their money from, like, some magical place. They get their money from our taxes. We pay them, we support them. They are public servants. And that means they have to serve the public. If the public is just outrageously upset about a bill that is, to quote the Faculty of Advocates, not my own words, rather draconian, then I think that's something that they would do very well to take on board. I mean, you can't. So when we're talking about laws, right, we want a law that the public are going to voluntarily accept. People often think that the point of the law is to sort of force people to abide by this law, even if they don't want to abide by it. And that's not really what the law does. That's actually what a bad law would do. What a good law, effective laws, want to do is they want to encourage the public to voluntarily change their behavior in accordance with the law. And, if the public doesn't change their behavior in accordance with the law, if the public doesn't accept this law as being valid, as being good, it doesn't recognize it as law, then in that case, you've got a very bad law, because the cost of enforcement is just too high. You can't put everybody into jail, right? If everybody is insulting everybody else all the time, you can't throw everyone in prison for 7 years. You can't use all of your resources just to police this one particular piece of legislation. The cost of enforcement is way too high. It's not a practical thing to do. It's sort of like the example of the 1700s, where there was window tax, right? So in the 1700s, there was a law that said you had to pay X amount of tax per window in your house. And the public obviously were like not having it. So they went and they boarded up all of their windows. And then when the tax man came around, they said, well, there are no windows here, as you can see, so please jog on. And in that case, the laws had to change because they weren't effective laws. The cost of enforcement was just too high. A law that is so deeply unpopular is not a feasible law. It can't sustain itself.
Yep, absolutely. We have another interesting question from Matthew again. He asks, would you agree it is somewhat problematic by having legislation rather than common law, judges' decision, criminalising this area? Judges may be able to take each case as it comes. Legislation is more of a line in the sand with little room for manoeuvre.
So I think this comes down to a very interesting theoretical question that we want to ask ourselves. Namely, there are costs and benefits to legislation versus common law. So on the one hand, if we have legislation, the benefits of it is that it's very clear cut, right? The public can easily access it. They can read it. They can, try and surmise what it means and therefore act in accordance with it. The downside is that if we have legislation, like Matthew said, it's much more rigid. So it's much harder for the courts to be flexible in their approach. They do have flexibility, right, in how they interpret, for example, abusive, or how they interpret threatening, but they don't have as much flexibility as they would in the common law. So a benefit of the common law is, as Matthew said, that the judges have more scope to develop it. They have more scope to sort of apply their minds to the cases before them. But the downside of common law is that it comes at a high public cost, because it requires people, again, to go to court to find out what the law is. And every time someone has to go to, as a lawyer, and I do it too, as a lawyer, I talk about going to court as if it's just like, popping down to Tesco, but it's not, right? It's this massive thing. That's why, threats of legal action are so effective, because nobody wants to go, even if you know you're right, even if you are without a doubt, the good Lord came down from above and said, Jade, you are 100% correct, my child, and went back up. That's still going to come with a very high personal cost for me as the individual going to court. So I think that you need to be able to balance those two things. I think having legislation about hate crimes, again, isn't a bad thing because it increases access for the public so they know what to expect. And I think that the language in the hate crime, except for the word insults, could give the court reasonable scope to maneuver on a case-to-case basis. So remember, the reasonable person has to find this communication or behavior to be threatening or to be abusive. And the reasonable person is a well-established objective standard within the common law. So there is scope within that. So it's not this like rigid, terrible bill. There are rigid, terrible portions within the bill, but the bill itself is not necessarily problematic.
Thank you for that. We have one final question from the Q&A, and then we'll ask our question that we always ask every speaker as a society and close. So that question is from Megan in the Q&A, and it says, this is probably a reach, but do you foresee an issue of people trying to use the bill, if passed as it is, against those who refuse to express a view in line with the rights of a protected group, due to the potential view of the refusal being insulting in itself? For example, in the Lee versus Asher situation, the refusal to ice the cake in support of gay marriage could be seen as being an outspoken and implied insult to the gay community or supporters of the gay community.
Is this Megan Bertie?
Yes.
Hello, Megan. Megan is my student who's writing her dissertation on how you balance freedom of religion against interest groups. This is such fun. Okay. What I think is, there is the risk of any legislation being abused, right? There's the risk of any laws being used by people who have bad intentions, by people who have a bad will, who want to abuse the system. What we have to ask ourselves is that abuse worth the benefits that it has for the people it's actually protecting? And I think in the case of the hate crime bill, again, very much save for the word insult. I think that it does do a lot of good. I think that this also goes into like a much more philosophical question, a much more philosophical topic. That is something I've also sort of grappled with, which is, why do we seem to be intolerant of other people's views just because they are, a view that we don't agree with? And, I've been reading up about this, and I found a lot of academic literature that's sort of says social media has created a narcissistic echo chamber in which we live a significant portion of our lives, right? The literature overwhelmingly in this area supports the hypothesis that people who use social media, which is everyone, myself included, we tend to associate with people who share our worldview and consume information the way that we do. And in fact, the literature says that we don't just choose people and information that confirms what we want to hear. We actively ignore, we actively reject people and opinions and news that questions this worldview. So we're forming polarized groups around these sort of shared narratives on social media that make us feel good about ourselves because they give us sort of affirmation. And this is sort of coupled in with a loneliness pandemic that a lot of people have. So even though we have social media that connects us, a thumbs up isn't the same thing as a big hug, right? It's not the same. So we don't challenge ourselves so much anymore. We create these sort of cultural forms of puritanism, right? And tribalism along the lines of people who think like me are good, people who have opinions like me, I value those. And people who don't think like me, they're evil and their opinions need to be silenced or expunged. But it's really necessary to be able to encourage and allow people to disagree with your views, right? To challenge you. if you don't allow people to disagree with your views, if you don't allow people to challenge your views, then you are living in a tyranny. And, you know, as in the end of The Sixth Sense, you are the tyrant. And that's deeply problematic. And by the way, I take that myself as well. So any of my students will know when we have classes, we enter into debates back and forth. And, you know, obviously I have opinions. I'm not a vegetable, right? So I have opinions on things too. But that doesn't mean that I think I am the, you know, bearer of truth, that I am a demigod here on earth who knows all. I don't. And if you have an opinion that's different from me, I should be able to entertain that opinion, even if I don't become convinced by it. And that doesn't make you a bad person, because our egos should not be so tied up in our particular opinions. I should be able to have a friend who is conservative, a friend who's liberal, a friend who's Greens, a friend who is just, you know, a hippie who doesn't vote for anyone. You know, you should have a diverse range of people who you value as people, not, you know, political ends. So I think it's a social problem. I think that the question Megan's asking, to my mind, is more of a social problem than a legal problem. And how do we solve a social problem? I mean, you can't, I mean, that's a really difficult one. And to some extent, it takes autonomy. You have to want to solve it. You can only make a change if you feel like there's a problem. If you don't think there's anything wrong, how are you going to take steps to solve it? And that's a really big issue. And like, I don't have a definitive, I wish I did. I wish I had a definitive answer. And then I'd take this YouTube video and I'd share it with everyone. And I'd be like, you know, here's Dr. Jade, she's going to solve your issues. But I don't know the answer. I think though, having the conversation is the first step to finding an answer.
Absolutely, thank you. Well, that takes us to the last question of tonight's event. And as Lee said, this is a question that we like to ask all of our speakers. As we are evidently the Free Speech Society, why is free speech important to you?
Why is free speech important to me? So, right, I think that free speech is really important because, well, okay, so from my point of view as a university lecturer, right, to me, the whole point of coming to a university is necessarily to make you break out of your comfort zone, right, to challenge all of the things you hold near and dear, to literally to challenge the core of your being, right? To expose you to ideas and thoughts and arguments that exist in the world, whether you like them or you don't like them, right? And you need to be able to be aware of these differing opinions, these different ideas. Like I just said, you have to be able to entertain a view without necessarily adopting it. Because if you don't, if you choose to limit, if you're willfully ignorant of what literally half of the world who disagree with you think or do, then, you know, that is a very ignorant way to be. And ignorance, to my mind, seems to be the antithesis of what a university is supposed to stand for. A university is supposed to be, I am presenting you with a smorgasbord of what the world looks like. Have fun, my children, find yourself within it. That's kind of the point of university, and that's what I find my job to be. And I would have a very difficult time, I feel, doing my job if I didn't have freedom of expression, if I didn't have the freedom to have a sort of Socratic back and forth with my students. And likewise, my students would have a very difficult time if they were afraid to say something in case, you know, the rest of the class ganged up against them or something. So, you know, I think in education, which is what I can speak to, it's you can't have education, you can't educate, you can't move forward unless you have freedom of expression, unless you acknowledge there's something in front of you to move towards.
Thank you very, very much for all of for the time that you've took today to speak to us. I mean, for myself, as someone who's been interested in this bill and its developments for a long time. It's really interesting to hear the perspective from someone who's involved in law as opposed to someone in the sort of political world, because you see a lot of commentators just talk about this and they'll have their gripes with it, but won't really give a full comprehensive answer as to what the problems are specifically with the bill. So I think that you've really helped to break down the issue with the bill, and I would agree specifically that the problem is with the insult section as opposed to the idea of trying to protect people from abuse, because like you said, obviously it should always be our goal to protect people who are vulnerable from abuse of any kind. It's the job of a modern civilized society. And I'd also like to thank everyone who took part in today's talk, anyone who put questions in the chat or just watched us. We will have our final talk of the semester next week, next Friday, with David Booth. And with that, that's us finished. Thank you very much once again, Jade, for speaking to us today.
Thank you very much for having me. Take care and happy Easter.
Thank you.
You too.
Cheers.